The lead investigator in the Senzo Meyiwa murder trial, Brigadier Bongani Gininda, has told the court that accused number 2, Bongani Ntanzi, wanted to get into a plea bargain and testify against his co-accused. This came out in Gininda's affidavit that he filed for the warrants of arrest for accused number 1 and 2. Earlier, the lawyer for accused number 1 and 2, Advocate Thulani Mngomezulu, argued warrants of arrest for his clients were irregular. Let's get the latest now with Newzroom Afrika's Linda Mnisi, who is attending proceedings this afternoon. Linda, good afternoon to you. So from the lead investigator, he indicates that this initially was a robbery gone wrong, but that was later changed to a contract killing. What did he mean by that?
Well, Clement, you'll remember that he was reading out the affidavit that he filed in the application that was made by the prosecutors to obtain warrants of arrest for accused number 1 and 2. And the reason why we even got to that point was because the lawyer for accused number 2, Advocate Mngomezulu, was arguing that those warrant of arrest were obtained unlawfully because the accused at the time were already in custody, and that he did not disclose that information to the presiding officer who was presiding over that application for the warrants of arrest. And Brigadier Gininda, in fact, the lead investigator, argues that that particular point around the address was not important, it was not a requirement, and the only thing that was required in that application was the evidence that they had against the accused persons and why they wanted that warrant of arrest to be issued against them. So he then details exactly what is in the affidavit. He reads the affidavit, which then contains what the case is about, leading to the point where he reveals that initially what they thought this case was about a robbery gone wrong, but then it emerged through evidence that they obtained that this was in fact a contract killing. Let's take a listen.
Investigation which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa.
So in that same affidavit, Clement, he also goes on to detail the involvement of all the 5 accused. I think this is the very first time that we get to hear some of the accused and how they were linked to this particular matter. For example, if you remember, we hadn't heard much around the involvement around accused number 4, Mthokoziseni Mapisa, and he reveals that information and how he's linked to this particular case, where he was guarding against, anybody that may appear. He says in the affidavit that he was also armed. Accused number 5, his involvement being with the getaway car, and how, of course, he was linked through other witnesses as well when it comes to that getaway car. But later then, we hear evidence from the defense saying that he did not voluntarily make that particular confession. And then Brigadier Gininda revealing the circumstances, particularly when it comes to the confession that was made before Magistrate Grenier, where the state essentially says that he made that particular confession, in the presence of his lawyer, who is Ntokozo Mjiako, but goes on to say that there was more than just a confession, that they stood by that confession and wrote it down. It was written down that they in fact stand by that confession, and that arrangements for a Section 105A in the Criminal Procedure Act were already underway, and those procedures of a Section 105 involve negotiating for a plea bargain. Let's take a listen.
The second part, my lord, the accused 2 in particular, then the second confession was made in the presence of his attorney to the magistrate on the 24th of June 2020. But furthermore, my lord, there was a 105 engagement in terms of Criminal Procedure Act, Section 105 capital A, between the state and the accused while he was legally represented. And in the documentation that we have, they firmly say they stand by the 2 confessions that were made by accused. And he elected, as part of his plea bargaining proposal, my lord, I must say this because the assertion is that they never made any statement. insofar as admitting the statement he made, went further in proposing a plea bargaining that he will plead guilty and testify against his co-accused. That is the extent of the discussions between accused two and the state. So those are the reasons, my lord, why I will not believe now that all of a sudden those statements were not made. There wouldn't be that discussion insofar as accused number 2 and even accused number 1 in all the appearances, not 1, 2, or 3, even in Boxback, on the first appearance, my lord, none of the accused, this is 1 and 2, raised the inadmissibility of the confessions that they've made.
So that's the lead investigator, Brigadier Gininda, who is then asserting their stance as a state that they did everything according to book and that those confessions were made freely, voluntarily, and without any undue influence.
Linda Mnisi.